Hello, hello, hello. It's Tracy B, the divorce solutionist. Good afternoon, good evening to all of you out there in cyberland. Anyway, um, so today, oh my God, today I ran across something very interesting. Lately, I've been trying to scope out some topics or issues that are not um, repetitive, like I haven't talked about repeatedly. It's kind of hard because, in family law, the issues are generally the same. They get a little nuanced because everybody's circumstances, character, personality, traits, all that stuff, it differs. But for the most part, the issues are, they run under, several of the same categories: custody, paternity, visitation, child support, property division, blah, blah, blah. Um, but I was scrolling through Facebook today and I ran across something very interesting. And I decided to talk about it today because it's something I never would have thought to come up with on my own. Okay, I'm going to be very honest about that. Um, so I I was going to do tea today, but I'd rather do. Actually, this is like tea because it was posted on. I don't know if you guys know who Zane is. She's an author, but it was posted on her page, and they were seeking her opinion about a topic, and I thought it was interesting. So I'm going to talk about it now. Excuse me, let me fix that. Um, so I'm going to read it to you. It's kind of long, so where I can skip over some things, that's what I'm going to do. But it's really, really interesting. Okay, so the writer writes, "My husband and I met and fell in love. Chemistry, love, blah blah blah. It grew immediately. He's amazing guy, loving, kind, great communicator, well educated, blah blah blah. We met in January and we moved in together in July. I got pregnant in August. His first baby, but my second. Our son was born in March. We married in April. At this point, we were literally living the dream. So let me give you a little backstory. This is what she writes. Let me give you a little backstory. My husband and his ex were together for 6 years and they were engaged. She tried getting pregnant and could not sustain a pregnancy. She had several miscarriages. They went to a fertility clinic and tried in vitro. And again, she lost the baby, unfortunately. They had embryos stored away, but she could not use them for a set period due to her almost dying from pregnancy failures. In December, after my husband and I were together for almost a year, he got a call from her and she asked him to sign away his rights to the embryo. And they received a refund, which they split in half, and he assumed they were disposed. That's the problem. If he signed away his rights, why would he think they were disposed? Okay, but I'm getting ahead of myself. 3 months after our son was born, he gets a call from his ex, and she tells him that she's pregnant by him, and the baby is due in a month. She used the embryos and got pregnant and had his baby. She didn't know he was married or that he had a baby. Because of the waiver he signed, he has no legal rights or obligation to the child. The child is now one, and he's minimally involved in the baby's life, and he has no desire to be more involved. He's an amazing dad to our two kids and a fantastic husband. He calls and checks in occasionally and sends small gifts here and there, but that's it. He's very hurt by what she did and very angry. I've given him the space to basically handle the situation however he sees fit. So the writer writes that she feels torn about the whole thing because she wants to know if he's considered a deadbeat because he doesn't contribute to the child's life, despite how the child was brought into this world. So, but that's a whole nother section. So, um, yeah, yeah. If you're responding the way I think you are, then yeah, you're stunned by this, okay? Because this is a lot to unpack here, and I don't know if I'm going to be able to do it all in the next 30 minutes, well, 23 minutes, but I'm going to try because this is interesting. Okay, first of all, When you go through IVF, if you go through IVF and the eggs get to the point that they're embryos. First of all, when you go, you should automatically they have you sign contracts. And when you sign those contracts, usually those contracts have a provision that covers what happens in the event that one of the parties die or separate or divorce or whatever. And it usually says that either one of them could either, I don't know if they actually say that. I think they can agree to that either one of them is able to take the embryos. But what normal standard contracts have is that they're either disposed of or donated. Yeah, disposed of or donated. Okay. And I think, like I said, I don't know if it's standard that either party can actually decide to take the embryos. I think that's something they can agree to and add to the agreement, but I don't think that's standard. I don't remember. I actually did IVF to have my son, but I don't remember what the agreement said. Yeah, it's no secret. I tell people all the time that I did IVF to have my son. Even knows it because I think it's a miracle. I think it's fantastic that some women are able to realize a lifelong dream of becoming a mom and dads, men becoming dads through ART. So, I'll tell anybody who asks, what I did to make sure um, IVF was successful with me. But so, yeah, so I did IVF to have my 8-year-old who'll be 9 next month. And we had no problems, none whatsoever with the pregnancy, the delivery, nothing. But I digress. But I don't remember what the provisions said about in the event that my ex-fiance and I split. Um, I don't remember. I think I was too hyped up about, going through the process. But anyway, that is standard language. So what she did with him signing away his rights to the embryo, I mean, he signed away, because that's legal. If the contract was, it wasn't done under duress, he was aware of what he was doing, then, him signing away his rights to the embryos, that's an option. That's what I said, that sometimes it can be included in the agreement, or there can be an agreement afterwards that either by, that the parties come up with them amongst themselves or by court, if they get the court involved. But either way, him signing over his rights to the embryos, that's perfectly within. So, the irony is that it's not that easy when the actual kids are actually born, because that's been coming up a lot lately too, where I've been seeing a lot of questions about how to get dad to sign away his rights, to terminate his rights. And unfortunately, once the child is born, that's different than when they're an embryo, to the extent that even when parties decide to go to court to fight over embryos, they're not looked at as actual humans. Sorry, they're not. Most courts look at them as property, and they will address the case as such. So they will do an equitable, would do something. They will employ some sort of test to see whose interest overrides who. The mom's interest to be a mom, or the dad's interest to not be a dad, or vice versa. So him signing away his rights, he was well within his rights to do that. That wasn't the problem. The problem is he thought that meant that the embryos were destroyed. I don't know why he would think that. Signing away your rights and destroying the embryos is not automatically one and the same. So when he signed away his rights, he should have read what he signed to make sure that those embryos were going to be either donated or discarded. Okay? Because whatever he did, he signed what he thought he did, there was a huge, huge, huge mistake on his part. And unfortunately, now his now wife has to walk around, feeling some way about the fact that there's another child out there with his DNA, with his genes, with his blood, that he's not really active in their life. So it's not just affecting him and the child's mom, but it's affecting his own wife and his own kids, his own family, because he made that mistake, and it may cost him morally, ethically, emotionally, psychologically, all those things. Okay, maybe not financially, and I'm going to get to that. Okay, but he should not have assumed that meant that the embryos were going to be destroyed. That was the biggest mistake. That was the first mistake he made. Okay. So say he signed and the eggs were supposed to be destroyed and they were not. Then he may have he might have had a civil suit against mom for doing that. I mean, if she got pregnant with the eggs against his, his knowledge, whatever, that's something you can't reverse that. The kid is born. But he could have a civil suit for emotional distress, fraud, misrepresentation, negligence, a whole myriad of things. I'm not talking about torts right now or personal injury or liability, because that's not the topic of my Thick of It Thursdays. But I just wanted to mention that yeah, he may have a potential, he might have had a potential suit against mom if she had duped him into thinking that the embryos were going to be donated or discarded, and she wound up using them. But that's not from what I read, that's not the case. He just thought that they were going to be discarded. It doesn't mention that she tricked him into thinking that. So okay. So now she has the baby. What obligation does he have to, one, be in the child's life, and two, to financially support the child? Well, although he's dad biologically, legally he's not. Yeah, let me repeat that. Biologically, his sperm helped create the embryos at the IVF lab. He signed away his rights to the embryos when him and mom broke up. So legally, he has no standing as dad, legally. So what that means is he can't go to court and fight for visitation. Well, you know what? He can. He can. This is such a nuanced situation that he probably could entertain a judge with this action if he decided to take mom to court for visitation or custody. Legally, as it stands right now, he has no standing, because even though if a blood test was taken and it would be proven that he is dad, he already signed away his rights. He signed away his rights to the embryo. So what that means, and what I'm saying is how the legal concepts play out. But you know what? Because this is such a nuanced situation, and family court, we know, is a whole different venue and environment on its own, that a judge may decide something entirely different. The judge may say, you know what? We know you signed away your rights at the embryo stage, and we know legally you don't have any standing, but in the best interest of this child, the best interest of this child will always trump, can always trump any other legal concept that's out there floating around. If the best interest of this child is that you have access to the child, visitation, whatever it is, then, hey, we'll grant it. I have not seen a case like that. I'm just speaking hypothetically. I'm giving you an idea of how these little concepts come into play and how they may play out, especially in a very esoteric scenario like this one. Okay. The flip side of that is, can mom sue him for child support? Okay, because legally he's not dad. Biologically, genetically he is. But he signed away his rights to the embryo, which means that they became the property of mom. The embryo became the property of mom, but the baby, the child, the human, is now in custody. In the custody of mom, physically and legally. What does that mean for child support? Technically, legally, he's not obligated, because he signed those away, right? Even if the judge determined, even if he didn't sign away, and either or took the other to court to either discard the embryos or to keep them. Say mom wanted to keep them, he wanted to have them discarded. even if the judge had to make that determination, and usually what the judge will do is weigh the interest of the woman wanting to be a mom against the interest of dad not wanting to be a dad and not wanting to be responsible. I don't know how they come up with that, but just from the little research I've done, that's usually how they do it, how they weigh that. Again, that those embryos will be considered property, so it's not the same. It won't be given the same analysis as an actual human. If we're human, if the embryo was an actual child, we know it would be the best interest standard. But because they're not seen as such, they're property, and they're analyzed and assessed similarly to distribution or division of marital property, real property, cash, cars, stuff like that. And I'm not trying to say that embryos are just like a car. We know that. But from the court's standpoint, from the legal standpoint, um, embryos are seen as property and not as actual humans. So that's the analysis that the courts would actually employ if they took it to court, if he did not sign anything, if they actually either one of them sued the other. That's how they would come up with that decision. I mean, even doing research, this issue is, you would think is really, really replete, but it's not. It's not something that, case law is readily available for that. I mean, to be honest with you, I only did a few minutes of research, but just from the few minutes of research that I've done, it's pretty still up in the air how the courts rule in these cases because it's not so common or typical. So mom wants child support. Can she get child support from the bio dad, even though he's not legally dad? Probably not. Probably not. Because in that respect, you can't make him be financially responsible for something that he signed away his rights to. Okay. And I know many of us think that family courts and their laws and their rules and their procedures and their statutes and all that stuff can be so unfair and biased and, crazy and quirky. The one thing, he has rights. Dad has rights. As an American, he has fundamental rights. And that is that he can't be, well, I can tell you some cases where dad can be responsible for kids that are not his. As a matter of fact, I will do that one day because that's crazy because it does happen. It does, and that's the craziest thing that happens that I've seen in my almost 20 years of being in the family law arena. But again, I digress. Um, so mom can't get child support. Dad may be able to get access or visits or parenting time, whatever it's called, wherever you are. How about name? How about he wants to add his name? That goes along with custody, access, visitation, blah, blah, blah. Suppose he wants to actually request paternity so that he can do an affiliation or acknowledgement of paternity so that he can actually be noted on the record as dad. Whoa, now that's interesting. That's very interesting. And I'm not saying that he goes to court seeking this, and because if mom doesn't object, of course, the court is going to allow him. But if mom is objecting to this because she said, yo, I wanted you to sign away your rights for a reason. I don't want you in his life or her life. You've done your part. I'm good. That's it. We don't need you. But dad's like, no, I have a moral obligation. I can live with myself. I need to make sure that this child knows that they, have a dad and, they have a decent dad. And I want to make sure I give this child the same opportunity I give my own children, born out of my marriage. And I need to put my name. I need to do paternity to prove that I'm dad. and to get an acknowledgement of paternity or parentage, whatever it's called in your jurisdiction, so that I could be identified as dad on his birth records. That goes along with the access and the custody and the visitation. If dad can actually make an argument that it's in the child's best interest, again, the best interest of this child didn't apply as an embryo, but it applies once the child is born. If dad can make that argument, he might have standing. That would be a very interesting litigation. I would actually love to see that play out. I really would. It cost them an arm and two legs, but it would be very interesting because I could see motions upon motions upon motions with case law, you know, rulings and, you know, all kinds of things, discovery, and oh my goodness, it sounds so juicy and meaty. I wanted to weave in, I was trying to weave in other issues into this hypothetical. So we covered support, access, visitation, parenting, birth certificate, birth records. I even threw in a little bit of civil liability in there. Who suppose his wife wanted to divorce him, and because she wants to divorce him, he now wants to allege that the baby that was born by way of the embryos should be considered for as an obligation of his for child support, for future benefits, anything and everything. That'll be interesting too, because usually in a divorce, it's only the spouses that are actually involved in the matter, in the litigation, not a third party. You can't bring a third party into the divorce, but the divorce can actually track any other parallel litigation. So what that means is, if there was some pending, case with mom of the embryo child, the judge in a divorce could actually, pace the divorce along the time frame of the actual other litigation to see what decisions come out of that before he makes a decision in the divorce. I'm just trying to sort of weave them in a creative way, just trying to give you an idea of how that works. So let me do a couple of twists on this scenario. So the most common situation in these kind of embryo cases is a divorcing couple, and they have embryos, and the wife wants the embryos. She would like the opportunity to become a genetic parent, and the husband is willing to help her achieve this, but does not want to assume any rights or responsibilities toward any child she has. Since the embryos were created during the marriage, the husband will be considered a legal father without the use of one or more of the following creative legal techniques. Okay, so this is kind of going to address a little bit of what I was talking about. First, create a contract whereby the husband transfers full title of the embryos to the wife, who then assumes the sole cost for storage and fees related to the cyber preservation of the embryos. This contract may not be enforceable under the law of many states, but it does serve to illustrate and memorialize the understanding and intentions of the couple. And again, when you sign a contract, there are contracts that you and I can enter into. We can enter into any agreement we want, but when it comes time to enforcing it, if either one of us doesn't abide by the agreement and we want to actually get a court to enforce it, that's different. Because just because we enter into the agreement voluntarily, amongst ourselves, no duress, blah, 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 it doesn't mean it doesn't void some sort of law or statute or principle or public policy. So it's going to be up to a court to decide whether or not they're going to actually enforce it. Enforcing it meaning making the one who is actually violating the agreement comply, or vice versa. Okay. So just because we into an agreement, because that's what dad could have done too. He could have said, if he really thought that the embryos were going to be destroyed, what he signed said that, he could have taken mom to court and said, you know what, I think I mentioned that, but he also could have taken mom to court and said, we need to enforce the provision that said that the embryos were going to be discarded. Now, once the embryos were used, there's nothing they could do about it. But what could have happened is a judge could order, to avoid any of the custody, visitation, child support, the judge could order that because mom or the ex didn't actually abide by the provision that the embryos were to be discarded, and she went ahead and used the embryos and had a baby, that this any further obligation, legal obligation, financial obligation to him will be, is void, is non-existent. It can't happen. It's unenforceable. I'm trying to use legal terms without confusing you too much. But I try to stick to using layman's terms for things. That's why I pause a lot. It's hard sometimes when you're used to using legalese. But additionally, it's recommended that the couple include specific language in their property settlement agreement or divorce decree that states the embryos are the property of and belong solely to the wife, who shall have the ability to make all decisions regarding future disposition of the embryos, including transfer to her uterus or that of a gestational carrier, which is a surrogate. Any child produced from these embryos will be the sole child of the intended mother legally, and if the embryos are not used for reproductive purposes by the wife, they will be destroyed. Okay. That's usually the language that's in the either in the IVF agreement, or yes, it could be in a marital settlement agreement or divorce decree. Okay. So one may ask, is this enough to protect the competing interests of both the husband and wife? Perhaps, but it's best to have the couple agree in the divorce decree or the marital settlement agreement that if a child is born from the embryo, each agrees to participate in court proceedings and request that a court formally terminate through a court order any parental rights the husband may have to the child born from an embryo created during the marriage. That was basically what I said a minute ago, that the court can actually order that. Even if they didn't ask for it, the court can actually order that the parental rights of the dad were terminated as a result of mom failing to stick to or abide by the terms of the agreement. And the other scenario that's pretty common is when, let me just say this. Other alternative is when husband will not permit the wife to use the preserved embryos. So currently the law may be on the husband's side if he has decided he does not want to procreate, because many courts won't force him to be a dad against his will. Again, that's something that that's weighed against moms. It can be weighed against mom's desire to be a mom, his desire to not be a dad. But for the most part, courts won't force dad to be a dad. But as noted above, embryos are in a category of their own. So, for example, she can offer and agree to only use the embryos for one pregnancy and birth. She can offer to relinquish ownership of something that, in exchange for him giving her the right to do that. Most divorces don't go to trial. We know that, right? But more often, conflict is ultimately settled amongst the parties at a mediation, even at settlement conferences or whatever. So at that time, they can actually work out the terms, specific terms, the express terms of how the embryos are going to be handled and what are the consequences if either one actually violates, well, usually mom, because if she has them and she and the agreement is to use one or dispose of them, and she doesn't, and she has the baby or has babies, then again, dad can actually sue for, he can't get, the baby's born, but he could get his rights. He can actually have the court do an official order terminating his rights. Okay, that's a little different than what the guy in my hypothetical did, but I wanted to just deviate a little bit so I could give you some, various scenarios to see. This is an interesting topic. I can go on for hours about this, only because it's so again, it's so nuanced, it's so unique, it's so uncommon, something that's not litigated often, that the turnout it can go either way. I mean, there's some basic principles that apply no matter what, and I think I discussed those, but for the most part, it's still very interesting to see how certain legal concepts intersect or overlap, especially on an issue that's not always brought up in court. So I'm going to end it there because I just wanted to talk about that. That was just interesting to me. I hope somebody got something out of it. Anyway, I wanted to take a minute again to just talk about my services, because I am always improving and trying to make things, tailor things to what potential clients are seeking. So one of the things I really wanted to mention today is my strategic action plan. I'm really a big fan of that one because it's a one-time thing, right? It's a one-time thing that I can do for you that can help you. It'll serve as a roadmap throughout your whole case. It can. If your case is a few months or a few years, it can serve as a roadmap because it will have all the issues analyzed. I mean, analyze. Like I take days to do it because I do legal research, case law. I try to, investigate the lawyers, the judges. And somebody asked me the other day how. I'm not going to tell you my secrets, but yeah. So it's really quite intensive. It's very intensive. So I think it would benefit those of you who have a lot of issues, who have custody, support, separate property being questioned, marital property, hidden assets, those kind of things. Very, very useful for you. It starts at $795. It's usually several pages long. It usually takes about a week, sometimes longer, depending on the issues. But I'll ask you for any court documents you have. I may ask you for more as time goes on to help me narrow down stuff or to locate stuff or to analyze more in depth. But it's good. I use my skills and my expertise as a former family law attorney, mediator, guardian ad litem, writer. All my skills that I developed in the last 20 years, I used to put into creating the customized roadmap strategic action plan just for you. So, and I think it's something that you should actually take advantage of. Just call me and let's talk about it, and we'll see if it's something that's that's good for you, that'll be suitable for you, beneficial for you. Can't hurt, right? So yeah. So anyway, I'm Tracy B, the Divorce Solutionist. You can find me at Facebook, the Divorce Solutionist is my business page. Instagram is the same thing. LinkedIn is the same thing. I am also the administrator of two groups, the Divorce Glow Up, which is for that one's is typically for people who are represented and unrepresented, meaning they have a lawyer or they don't, because that one focuses more on the complete process of divorce or custody, the emotional, the spiritual, all that stuff. And then the pro se divorce and custody group is more practical tips and insight and information for pro se parties. Pro se meaning self-represented or unrepresented parties who are going through divorce, custody, child support, whatever, anything in family court. So those are both on Facebook. So you could always find either one of those groups and join and take advantage of a lot of the free stuff that I put in there. Trying to think. Oh, my website is www.thedivorcesolutionist.com. You can schedule a 15-minute free consultation from there, or you can also reach me via email. Just ask me a question. The divorce coach esq@gmail. You can the first question is free. When you come back with 3 and 4 and 5 other questions, then I have to start imposing fees because I see people really trying to take advantage of that. So, but anyway, I'm accessible. I'm available. If you think you want to work with me and help you come up with a strategy to win whatever it is you're seeking, then please feel free to reach out to me. I am here to help you. Anyway, that is it for today. Until next week. Bye.